When somebody comes to court and say that I made this statement involuntarily, what the person is simply saying is that I did not freely make that statement. I did not make it out of my own volition, out of my own free will. So, what's the proper thing for the court to do? The court, most times, usually, always usually, would conduct a trial within trial. In that trial within trial, it's like a mini trial. You are calling on the prosecution to prove to the court that indeed the statement that the accused made at the police station was voluntarily made. Because if a statement is not voluntarily made, it means that it goes to no issue. It means that it is of no use to the court. But today's case, there's a difference. This guy is saying that I made the statement, but I'm going to retract it. That does not in any way affect the admissibility of that statement, meaning that the court will still admit the confessional statement. The fact that it is retracted, the only thing maybe it goes to the weight that the court is going to attach to it. But if a statement is involuntarily made, meaning that it was not willingly made, was made under duress, under torture, under several circumstances that the law does not permit, that statement is of no use. That piece of evidence is of no use to the court. But if somebody retracts a statement, it doesn't mean that the court would not admit it. It might now perhaps go to maybe the weight that the court will attach to that evidence. Besides, there were also other circumstantial evidence in this particular case that would have also nailed Aliu. So in essence, what we are saying is, if somebody retracts a statement, it does not mean the court will not admit it. The court will admit it. The court would also sometimes look for other corroborative evidence, like the evidence of the eyewitness who saw what happened, who was the person that was even robbed. The person came to court, told the court that I recognize this person, I know him. So what further evidence do you need to prove that this person or the accused actually committed the offense? So these are the two things that we need to distinguish between yesterday's case and today's case. Retraction of confessional statement does not mean it will not be admitted. But if somebody makes a statement involuntarily, under torture, under duress, under so much, beating, threat, coercion, and all the rest, that piece of evidence is not voluntary, and the law does not permit a statement to be made involuntarily. Statements ought to be made freely. They ought to be made voluntarily. They ought to be made with, a clear mind, not with fear of maybe danger or fear that this thing is going to happen to me if I don't make that statement. So that's something I think we should note in the two, and that's why the Supreme Court, ruled the way it did.